na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Bam bam. Oh na 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 na. Big it up. Oh na 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 na. Big it up. Oh na 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 na. Bam bam. Ba 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 de. Ba ba ba. Ba ba mi de. Ba 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 mi de. Ba ba ba.
Welcome to today's episode of Home and Away Jamaica. Your presenters today are Paulette Price and my co-host, Robert Taylor, attorney. But today, Robert's role is going to be slightly different. I'm going to be interviewing Robert, where today we're going to be talking about squatting, squatters in Jamaica and the laws around that, and how we want you to understand the law and how eventually we're going to tell you how you can prevent these things happening. So I'm going to start. So welcome, Robert.
Thanks, Paulette. Thanks.
Yes.
I say thanks for having me.
Yes, you can say that. All right. So let's start off, Robert, by just starting to talk about what is squatting.
Well, squatting, and we use a layman's term, squatting, but in law we speak of adverse possession. And so squatting are rights built up by third parties who are not the title holders of land. So persons who are not the registered owners of land may over time develop rights that give them legal interest in the land. And so maybe it's good to look at the whole concept and how the law of squatting or adverse possession has evolved. So effectively in land law, the Crown, or the government in layman's terms, has ultimate ownership over all land. And land was issued by way initially of leases. And so there would be a reversion where this interest in the lease could always go back to the Crown. And so ultimately, the Crown can at any time exercise its right for that interest it has in land. So we know, for example, if the government is building a roadway over land, they can, extract a portion of that land for their own use. And so the Crown reserves that ultimate right over land. And so the principle says, if we grant you an interest in land as a private landowner and you sleep on those rights, then we can take those rights away from you and grant those rights to someone who has a need for that land. So, land is this finite commodity that you have to use very carefully and expeditiously. It's a resource that must be used. And if you have no use for the land, then we, as the Crown, have the right to grant that interest into persons who demonstrate a need for the land.
So, Robert, then, what you're saying is that squatters have rights. Is that correct?
Squatters do have rights. And so that's how the English law evolved, and we are a part of that whole common law structure. And there is an Act, the Limitation of Actions Act, that prescribes ways in which persons can have access to land by way of occupation. And so both the common law and the Act sets out the specific criteria that needs to be met.
So people who occupy lands for a certain amount of time, obviously you're saying that they have some rights. So how do they turn that into them now becoming owners? Can they apply for titles? Tell us about that.
Well, the first thing, and let's assume we're dealing with registered title. So
right.
Let's say, and let's use an example. Someone lives in the UK, they own land in Jamaica, and they've migrated for 20, 30 years. Someone in the community recognizes and knows of their absence and decides to take steps to occupy that land. So the Limitations of Actions Act says first, for private land ownership, land has to be occupied for a continuous unbroken period of 12 years. In the case of publicly owned land, that time period has to be 60 years. So first of all, there's a time bar that has to be met. So simply moving onto the land doesn't grant rights of adverse possession. You have this time bar of 12 years that have to be met. In the UK, it's 10 years. In Jamaica, it's 10. You also have to demonstrate certain things. The law says your tenure must be open and notorious, meaning that your tenure must be visible and not a secret. So any onlooker, any officious bystander, someone passing, would think that you are the rightful owner of that land. So it means also keeping the world out at large. So that land should be fenced, there should be a boundary, there should be some continuous occupation on the part of the adverse possessor that shows that they are in possession. So it doesn't mean, for example, leaving early in the morning, coming late at night, and no one knows that you actually have continuous possession. You can farm the land, but in farming the land, the activity must be continuous and obvious. You can also build on the land, provided, of course, that your possession becomes undisturbed and unbroken.
Okay, so if, let's say, somebody occupied this piece of land and they showed continuous use of the land, they were farming, they built a house, and 11 years and 6 months later, the owner appears and says, I've been away and I didn't know you were on my land. Can that be broken?
It can, because the statutory period has not been met.
Right.
Also, I should add that there are some other evidential criteria that is used to determine whether there is a valid period of possession. And so the actual decision in relation to adverse possession is actually examined with the registrar of titles. Actually examines that application to make sure that the evidence presented is substantial. And there's this common view that if you pay the property taxes in of itself, you are entitled to an interest in the land. The payment of property taxes is just one of those limbs that we spoke about. So there are several others that have to be satisfied. If you, for some reason, got connection for utilities, for power, for water, those are also evidential of your continuous possession.
So how is it possible that somebody who's squatting can actually get connection of power and water when they don't actually own it as yet?
Well, in relation to utilities, it is certainly sometimes these connections may not be legitimate connections, but certainly in terms of electricity goes, the utility bill goes in the name of the tenant, not the title holder. And so persons can. Also, there are certain communities where the utility companies pretty much or very well understand the status quo and grant connection.
So how does the law really deal with squatters?
Well, my advice for someone who owns land and that land may be at the risk of squatting, and sometimes squatting or adverse possession may actually be a known party. It can be a relative. certainly you and I have been at forums, particularly in the UK, where someone migrates and a cousin or in-law remains in possession, and that person pays no rent, has an unbroken possession for the statutory period, is paying the property taxes, paying the light bill, and can make that application for adverse possession. So what you want to make sure is that you take steps to break that chain of possession.
Right.
So one way to do that is to charge rent. Enter into a lease with the person who's into possession. It can be for a peppercorn sum, does not have to be for market or substantial sum, just consideration that's sufficient to show that this person is here with your permission. Because an adverse possession application can only be approved where it can be shown that the possessor took occupation without the permission of the title holder. So with a lease, what you're acknowledging is that both the person in possession and the title holder have an arrangement for their occupation of the land. And so that would refute or diffuse any claim for adverse possession.
Okay, so that is if you know who the person is. So what happens where you have a squatter that has just turned up on your land and you weren't even aware of it?
Well, the first
so is there something else you can put in place to prevent that happening?
The first thing you want to do is, if you have land, particularly raw land that's not built on, you want to fence the land. You want to fence the land, have it gated so that it is clear that you have taken steps to keep persons out. That's the first thing. The second thing, if someone by some means takes occupation, then you want to issue notice for them to vacate the property and give notice that their possession is illegal. And if they don't vacate, then you would want to go to court, get a court order, and then have an court-appointed bailiff forcibly remove that person if they don't voluntarily remove themselves from the land.
So I'm going to twist up the story a little. What happens if we have somebody who's, so you can get these different twists in a story. I recently did a course and I heard a story about a lady who has a house on a nice piece of land. She lives in the house, but her daughter actually owns the property, and her daughter lives in Canada. She went to Canada for a few months to stay with her daughter, and when she came back, she couldn't put the key would not go in the door because somebody had moved into her house. So is that and apparently she had some problems getting this person out. So is that's a squatter, right? That person's become a squatter and they've taken over her property. The
person has squatted, but in law has not become a squatter because that interest in the land could not be transferred until an application is made. An application can only be made until those criteria that we just spoke about. Firstly, the limitation period of 12 years. So simply being in the house for a month, 2 months, 3 months, a year, 5, 6,
That's
7.
a burglar.
You're accumulating squatter rights, but you still have not crystallized, so to speak, that interest in the land to satisfy any.
So that person then would be termed as a burglar, and you would simply call the police and get them out.
Person would be certainly trespassing. Yes.
Yeah, trespassing. Yes. Yeah. Okay. So, is there anything else that probably I haven't asked you that you could cover on squatting?
Well, there even in respect of commercial property. I mean, squatting can be very passive, and so if you take note, for example, some commercial premises where you have roadways. So let's take, I think it's Ligani Lane Plaza.
Yes.
the plaza that you can cut through from Barbican Road to Hope
Yes.
Road.
Yes.
Right. So persons are given access through that public access through that parking lot, and it's used as a roadway. What you will notice is that once a year, the owners of that property will put a chain across the entrance to inhibit access. So they're breaking the chain of possession. So
Yes.
at no point can someone, simply claim a right, uh, to access that land by way of
Yes.
continuous use.
Yes.
And so, it's not uncommon. Certainly, we know, for example, I'll take Barbican Square, for example, where you have, some of the ladies we know selling fruit. They have occupied those lands for a number of years. And so when that land was being redeveloped, the property owners actually had to go into negotiations with them and offer some settlement, because they had been on the land for quite some time. So my advice is, in wrapping up, is that you want to be very vigilant. If you have left, you're no longer in the jurisdiction, if you live abroad, have the property fenced, have the boundaries bordered and fenced in. If you can't afford to do that, make sure that someone's continuously looking at the land, doing drive-bys, just to make sure that no one is in possession. If there's a house on the property, you want to make sure that the same thing or same steps are being taken. And if you have a relative, even a relative, I've had a case with a property owner living abroad, and her brother remained in possession to take care of her father. And the brother took steps to remodel the house, maintain the house. He paid the property taxes. And when we went to completion, there was a caveat on the property, because the brother was claiming an interest in the land for all the monies invested and improvements and so on. And so what we had to do was to enter into a settlement with him, and by way of agreement and undertaking to give him a specified sum on completion, he removed the covenant. So, sometimes you don't have to establish the full statutory period, but persons who are in possession, perhaps initially by consent, can become hostile and can prevent and hold up a sale. And so for practical reasons, your best option may simply be to negotiate with that person.
Okay, so have you ever had the experience where people squat on commercial land? Because you always hear about people squatting on residential land. Do you ever have many of those cases?
Not uncommon. You may have some cases, for example, in downtown Kingston. You may have cases just along the Spanish Town commercial corridor where owners have migrated. Sometimes owners have died without next of kin. And persons in the community will test the waters. So they'll move in very gently and gradually. And if their possession becomes uninterrupted, then that becomes there's a continuous period of occupation.
Yes. And once again, we advise people, if somebody takes over your property, please have them removed legally. Don't take action into your own hands.
Absolutely. And
always use the professionals. I didn't say at the beginning, but I'm certainly going to say it at the end, because that always works well. So let's sum up. I think squatting is a very sensitive area. And what I would say to any of you listening, you need any advice on any of these subjects, please make sure you subscribe to the program, like the program, so we can continue providing useful information. And once again, I want to say thank you very much to Robert for talking to us more about squatting in Jamaica.
Great sharing again, Paulette.
Yeah, excellent.
Oh na 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 na, bamba.